Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. Well, the House plenary has yet to vote on the impeachment complaints against Vice President Sara Duterte. The Senate is already preparing for a possible trial. The recent Supreme Court decision says the Constitution's directive for the Senate to proceed forthwith means acting within a reasonable time. What rules does Congress actually follow in impeachment processes? Let's get on point with former Senate President Franklin Drilon. Senator, good to see you again. You're looking well. Thank you for your time.
Pinky, and thank you for having me tonight.
Anytime, sir. Let's start with this probable cause issue. The House Justice Committee already voted. Balikan lang po natin. Sufficient in form, sufficient in substance, grounds. Tapos ngayon po, kakatapos lang po nung probable cause. All right, that was a unanimous vote. 58 members voted that there is probable cause. Did you see any problems, concerns during the conduct of the hearings?
I didn't see any, and I can, from where I sit, the House committee followed the Supreme Court decision to the letter. So maybe overdid it, and but I can see that. And I have no doubt that they will elevate the case to the Senate. The impeachment complaint would be elevated. And probably that is the reason why Vice President Duterte did not submit any evidence, because she assessed that no matter what kind of evidence she will present, chances of it being elevated to the Senate is very large, and therefore, as a matter of strategy, they say, let's do it in the Senate, let's present our evidence there. In other words, it is easier to get 9 Senate votes to dissent rather than have a majority in the House of Representatives to dismiss.
In other words, you're saying it's easier for her to win in the Senate than in the House.
Yes, and the numbers are less complicated. You have only 24 republics to talk to, and if you have 9, that's it. Now, if you look at it, today you have 9 in the minority in the Senate, and you assume that these are Duterte votes. So if that 9 stick together and would cast a negative vote, you can never convict. Now, of course, also the fact is, Pia is part of the majority, but is the sister of Alan. And I do not know if they will vote separately, but if Pia sides with Alan, there you are. You have 10.
But Senator, while we are looking at the numbers right now, that there is 9 in the minority and thinking that they will vote against the impeachment.
Against conviction.
Against conviction. Of course, we're getting ahead of ourselves now, bringing this to the Senate. Do you think that there could be possible evidence, pieces of evidence, that might change the minds or force them to actually vote the opposite?
You can never tell. Remember that I was a senator judge in 2 impeachment trials, and until the bank statements and records were revealed in both the trials of President Estrada and Chief Justice Corona, the general view was that they will be acquitted, but the bank records changed the picture, and in the case of President Estrada, the thought that the second envelope contained more damaging evidence related to the bank record. The prosecutors walked out because the majority refused to have it opened. In the case of Corona, the testimony of, I think it was Carpio Morales, who testified on the bank accounts, or somebody. And again, the trend changed at that point. So you'll never know, Pinky.
Anything can happen.
Anything can happen. And of course, the impeachment trial is a quasi-judicial proceeding, meaning that it is not based strictly on the evidence presented, because by the very composition of the Senate, you cannot expect them to vote strictly on the basis of evidence.
Yeah.
I mean, of the admission of the credibility of the evidence. You know?
At the end of the day, it really is a political process.
It is a political process, and that's accepted as the nature of an impeachment process.
When you were talking about bank records or bank accounts at that, I want to go back to what happened during the House Justice Committee hearing. Let's talk about AMLA. Was the House Justice Committee well within their rights to subpoena these transactions, suspicious and covered transactions of the Vice President?
Well, the bank secrecy law specifically provides in Section 3 that the bank records are confidential and may not be made public except one in cases of impeachment. Now, so that's why they subpoenaed the AMLA or AMLC. The argument is that the AMLC should not have made it public because that is prohibited absolutely under the Anti-Money Laundering Act. 2 points. Number one, the authorization or the power to subpoena is in the bank secrecy law, not in the AMLA. Now, second point, if you follow the theory that the bank records are absolutely confidential, even in cases of impeachment, then all that the respondent will do is deposit the money, and therefore, under the theory, you can never pry open the account, and you defeat the very purpose of an impeachment, which is to extract accountability. Mm-hmm. That's the point. The impeachment is to extract or to impose accountability on impeachable officials. And if you say, no, you cannot open that, then all I have to do, if I were the impeachable officer, deposit it all at the bank and nobody can prove anything.
But do you think there might be something wrong with some provisions of the Anti-Money Laundering Act? I believe it was amended in 2022.
I was the Senate President that the original law was crafted, and we were always conscious of the bank secrecy law, which was already existing at the time that we passed the Anti-Money Laundering Act.
Mm. Let's put that up on the screen because this is something we've been talking about over and over again. And I actually had the spokesperson of Attorney Manscarpio here last night. So nakasulat po kasi sa AMLA as amended in 2021, Information Security and Confidentiality. The AMLA, this is what they're using, and its secretariat shall securely protect information received or processed and shall not reveal in any manner any information known to them by reason of their office. This prohibition shall apply even after their separation from AMLAC. So the simple explanation would be, hindi kayo pwede mag-reveal in any manner or in any information. And yet, you have the bank secrecy law that actually says deposits. But here's where I wanted to ask you to follow up. Deposits are considered confidential except upon written permission from the depositor, pag pumayag po si depositor, or in cases of impeachment.
That's
Senator.
right.
Ito po yung
That's
sinabi
right.
niya. So, I was asking yesterday, this particular provisions in the law, nagbabangga ho ba sila? Are they conflicting?
First, they are not conflicting, but even beyond that, I'm even assuming, and I'll explain later on, it is not conflicting, but even if it's conflicting, you know, if you look at the principle is a repeal by an implied repeal is not favored in you interpret statutes. Meaning, you know, the argument is that it is an implied repeal because the AMLA did not provide for any exception. Now, the second point is the AMLC and the impeachment trial is to exact accountability.
Yeah.
You will defeat the whole purpose if you say that it cannot be
Bawal. In any manner or any
yes,
information.
and also it says shall not reveal. In other words, it
Shall not reveal.
shall not reveal, meaning that you cannot voluntarily go
To anybody and just reveal it.
to Billionario and say,
But Senator, did it mean that it requires a court order? Because if you're saying that...
yes, it requires an order from the impeachment court.
Did it say court order? Because that could be a technicality there,
Right.
because they can say this hearing is not a court.
It is not.
When it gets to the Senate, it becomes an impeachment court.
That's right.
So baka meron pong technicality dyan.
Alam mo, Pinky, how it is interpreted will depend on the majority in the Senate. And as we have said a few minutes ago, this is not purely a legal process, but a technical, not purely a legal process, but a political process. So,
Okay.
so from there, you can draw anything.
Okay. So, you saw nothing wrong with the AMLA showing up in the House of Representatives.
They were
in the House
subpoenaed.
Justice subpoena. Yes, sir.
They were subpoenaed,
And
so-
showing these
Yes.
documents, yung pong concerned and
Yes.
suspicious transactions. No problem there.
No problem there because they were subpoenaed, and that this is part of the impeachment process, and Congress is a separate body, and under the rules and under the Constitution, they will be the exclusive judge of the impeachment, and the complaint is part of the impeachment process. The impeachment process starts with a complaint, so you cannot say that this is not an this is the House is not authorized to subpoena, because impeachment is an exemption from the bank secrecy law.
And in fact, the bank secrecy law, okay. And in fact, in their rules, in Section 7, it actually allows them, because Congress, the House of Representatives, according to the Constitution, shall promulgate its own rules.
That's
and in
right.
their Section 7, it said that they can issue subpoenas, etc. But this is where the argument is actually being raised, that there could be a violation.
Well,
is the word I'm using.
That's right.
Okay.
And at the end of the day, the Senate must decide, and the Senate has the exclusive power to interpret.
What were your thoughts about the report of the AMLA? 6.7 billion pesos, Senator, in inflows and outflows. I spoke to the defense team at Attorney Michael Poe, and he was basically saying, let's be careful with this because ito po ay aggregate. Aggregate meaning kung ano yung nilagay mo, 10,000, winidraw mo, 10,000, 20,000 na yun. Naglagay ka ulit ng 100,000, magiging 120 yon. Nagtanggal ka ng 120, 220. In other words, lahat ng pinasok at nilabas mo, padagdag po sila ng padagdag. In fact, if we were just to show them the inflows and outflows, let's put that back on air, lumalabas po that the outflows for both was 1.55 billion pesos. The inflows, 4.43 billion. So meron pong sinasabing undetermined transactions of 791.1 million. Senator, again, what are your thoughts about that report coming from the AMLA?
Firstly, I have not seen the AMLA report, but from the media reports, they have reported the inflow and the outflow, as you just suggested. There is certainly more inflow than outflow. Is that so?
4.43.
Yes, for over 4 billion. This must appear in the statement of assets and liabilities because these are covered transactions under the Anti-Money Laundering Act, and also covered by the law on SALN. You are supposed to report your assets. Okay. The other argument was that, I heard it, these are not ours. These are only parang nakapark lang. That's crazy because the law is statement of assets and liabilities. So you must state the asset. If you say this is not mine, that is a liability, and therefore you must report it. It's not reported, so it's a violation of the law.
And speaking of SALN, again, there are questions on the Vice President's statement of assets, liabilities, and net worth. But we need to take a short break. We'll continue our discussion with former Senate President Franklin Drilon when we return. Stay tuned. This is On Point. Welcome back. Still with us, former Senate President Franklin Drilon. We jumped to the SALN. Of course, medyo kaugnay po ito nung AMLA report. There was, I know it was Congressman Joel Chua who checked it and saw that there were no cash on hand or cash on bank. I'm not sure if one or both. Basta there were 6 years na wala daw nakasulat na cash on hand si Vice President Sara Duterte. Is that odd?
Is that?
Odd.
Well, it is odd in the sense that the bank records are already made public. And certainly there is cash in bank at the very least. And that is an asset no matter how you argue it. And that is why you are required to report it in your statement of assets and liabilities and net worth.
But 6 years of no cash on hand or cash in bank?
Well, firstly, the actual records proves that is wrong. The actual record presented by the AMLC shows that there was cash.
Inflows and outflows.
Inflows and outflows, in fact.
And to follow up on that, Senator, Attorney Poa was saying that nalagay ho kasi sa others, hindi po nalagay doon sa cash on hand or cash in bank. It was put in, I think, others or various. Is that acceptable?
I don't know. I haven't seen this SALN. I do not know what others. As I said, you are supposed to state your assets and your liabilities. So that's in law you give it a plain meaning. So
assets, it's assets, liabilities,
and liabilities, and the form required of public officials when they submit their SALN is that you point or you specify what are your assets. Bank deposits are assets, no matter what you say, no matter.
I think there was a Congressman Ridon, who had asked for a clarification. That might not be the right word, or the format that must be used for the SALN if there is cash, if it can actually be put in others or others or various. I think hiningi niya po yun, and I remember Congresswoman Jinky Luiser said they can, pero they have ruled on probable cause already. So the box of BIR records, there was a box, Senator, with the ITRs or bank records of the Vice President and her husband, Attorney Manscarpio, to which the congressmen and women decided not to open.
Well, because it is only an investigation to determine whether the complaint is sufficient in substance. The matter of the ITR, or Internal Revenue Reports, in the judgment of the committee, there is already enough to establish that there is sufficiency in substance. And they didn't want to risk that anymore because the law specifies that you cannot make the income tax return public except in an executive session and
in aid of legislation.
In aid of legislation. So they were concerned that there could be arguments in favor of their having opened those BIR accounts. But for what? I suppose the theory of the committee that let it be tackled in the Senate because we do not need that for purposes of establishing substance.
Probable cause.
Probable,
actually,
yeah. Establishing that it is sufficient in substance. We do not need the ITR records.
But that vote had been made. 38 said would not open it. I think 6 said let's
6 or
open
7,
it.
yeah.
Natalo po yung
Yeah.
let's open it. But just in general terms, does the Justice Committee have the power to open that box without violating any law?
Well, the law specifies that it must be opened in executive session. So they could have done that. But
Was it in executive session and in aid of legislation, or in executive session?
I can't recall exactly, but one thing I remember is that it must be in aid, in executive session. And yeah, probably in aid of legislation. So again, there can be a debate there, you know. So,
But this is definitely not in aid of legislation.
so
Senator.
certainly. But then it goes to the Senate, and since the House is only determining whether or not there is sufficiency in substance, why should you risk going with the other party going up to the Supreme Court?
So you agree with that decision?
I
to open
fully
the box?
concur with
All
the
right.
decision.
Okay, now let's go to what will happen. A committee report on Monday that will be signed by the House Justice members, and then at some point, days after, this will be brought to the plenary, where they expect heated debates, because this is the time everybody gets to vote.
That's right.
And they need 1/3 to be able to confirm, impeach the
Yes.
Vice President. When it gets to the Senate, sabi na po ni Senate President Tito Soto, agad-agad. They will convene, sabi niya, even the day after they receive the articles of impeachment. Again, presuming that aabot po ito sa Senado. Quick question on this, sir. Did you get any clarification with the Supreme Court ruling on Forthwith? Lumabas po ito very recently, April
Right.
29. Ang sabi po ng Supreme Court, ang ibig sabihin po ng Forthwith, within a reasonable time, which may be longer or shorter, depending on the circumstances of each case.
Nobody agrees with that among the legal profession. I mean,
Yeah, you look, yeah.
but having said that,
But did it clear it up? Did this
you know, the rule in statutory construction is you give the word its ordinary meaning. Now, forthwith, what does it mean immediately now? But the Supreme Court said no, it's not necessarily so. But they said that it is discretionary, and the interpretation of the Senate is superior as to when they will convene. In other words, they recognize the jurisdiction of the Senate insofar as the interpretation of forthwith is concerned. So Senate President Soto said it will be tomorrow. And unless he is overturned by the majority, then the trial will take place.
But that is my question, Senator. Is it going to be up to the Senate President to decide now what forthwith is? Because if the Supreme Court says within a reasonable time, which may be longer or shorter depending on the circumstances of each case, that becomes a judgment call of the Senate President.
It is a judgment call of the Senate President, which can be reversed by the plenary. But until the plenary reverses it, he sets the date. Okay, we start convening tomorrow. If somebody questions it and says, you are wrong, Mr. Senate President, if one senator says, and that senator who questioned Senator Soto would have the majority, then Senator Soto can say goodbye to the Senate presidency.
So I guess at the end of the day, it's up to the 24 senators.
That's correct,
Yeah,
because
hindi
we
lang
are
po
an
si Senate
independent
President.
body. And at least the Supreme Court recognized that the Senate can interpret it in its own discretion.
Yeah, because basically there was a ruling also part of it, not in these words, that it's not just up to the Senate President, but the impeachment court itself, basically saying it's up to all 24
that's
of
correct.
you.
That's correct. But the way it is implemented is the Senate President and the majority leader, presumably with the support of the majority, says the trial will take place on on June 1 or whatever. Unless the majority of the senators says no, we will hold it in June 1 of next year. That stands. Now, if the majority of the senators says no, it should be on June 1 next year, then that's the end of the Soto presidency.
But Did this decision of the Supreme Court make the meaning of forthwith more vague? Did it add more questions, or could it have been an easier response on what forthwith means?
You know, I agree on the latter. It should have been an easier response. But as we have been taught in the in college, the Constitution is what the gods of Padre Faura says it is.
Yeah.
So we accept that. I accept that as a lawyer.
All right. Do you see an impeachment trial happening as a last question, Senate President?
Yes, sir. I think the Senate President Soto has said it will take place, and he interpreted forthwith as immediately. And that is something that the Supreme Court should no longer interfere with.
Former Senate President Franklin Drilon, pleasure to have you, sir. Thank you so much for your time.
Thank you for having me tonight.
That's On Point. Join us again on Monday, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.